Ladies and gentlemen, I got myself in a bit of a muddle last night trying to sort out what I should be talking about at this particular moment and for how long. And I've ended up by thinking what I ought to do is just read from my unpublished as yet book covering all that time that I first got involved with animal rights. I hope you'll forgive me if I read from the book. It hasn't been published yet, so it's a scoop. As regards ethics, I had already thought out for myself what I later realized was called utilitarianism. I insisted on applying this to all things who suffered pain. Animals in particular, as Jeremy Bentham himself had proposed around 1780. I differed from Bentham in not agreeing with his suggestion that the pains and pleasures of separate individuals should all be added together. For me, pains to be aggregated had to be felt by the same individual. There is a pain barrier around each individual. You can add up the pains within the same person, but you cannot legitimately add together the pains of separate people. Pain to be pain has to be suffered by someone. Bentham proposed that pain and pleasure could be counterbalanced. He said that one unit of pain cancelled out one unit of pleasure. In fact, most people dispute this. They see pain as being more disruptive of pleasure than pleasure is disruptive of pain. Furthermore, in a test, most people say that when given a choice of avoiding severe torture or having supreme pleasure, they would choose to avoid the pain. Both physically and morally, pain is negative. The word pain is used by me to cover all negative feelings, emotional and cognitive, as well as physical. What about the famous gang rape situation? This is a thought experiment where there are many rapists. Utilitarians like Bentham might claim that if the pleasures of, say, 100 rapists all add up to 100 units of pleasure when added together, and the lone victim's total pain adds up to only 10 units, then clearly the gang rape is amply justified by 100 units of pleasure to 10 units of pain. This seems shocking to me and unacceptable, but it seems to be what the standard utilitarian calculation can imply, i.e., the greater the number of rapists, the more acceptable the mass rape becomes. Surely this has to be wrong. My own theory of painism, where the adding together of rapists' pleasures is not allowed, does not produce such an awful result. Utilitarianism is the basis for the ethics of the future, I believe, but it still has to work out practical solutions to these problems. I think my theory of painism is the best way so far of modifying utilitarianism. After achieving my MA in experimental psychology at Cambridge, I spent 18 months studying in the USA, where the attitude towards animals, as exploited for food and research, for example, seemed even more primitive than in Britain. After qualifying in clinical psychology at Edinburgh, I found a job in the Warneford Hospital in Oxford, working mainly with disturbed students and teenagers. When in 1969 I published a series of letters in the Daily Telegraph attacking cruelty to animals and research, I was contacted by the novelist Bridget Brophy. She introduced me to Ros and Stanley Godlovich in Oxford, young graduate philosophers from Canada, who had just got a contract from Victor Gollancz to publish a collection of attacks on cruelty to animals to be called Animals, Men and Morals. The three editors, the Godloviches and John Harris, immediately invited me to supply the chapter on animal experimentation, which I did. Unfortunately, the editors later didn't tell me that they had deleted some of my uses of my new word speciesism in my chapter, and that they had added several further examples of cruel experiments to the 50 or so I had already supplied. These new examples, on which I was not consulted, led to threats of libel action from their newly named experimenters and to expensive apologies from the unfortunate publishers. Nevertheless, the book, their book, the Godlevich's book, was eventually published and received some positive approval. Furthermore, I'd spent a year mingling with young Oxford philosophers. I had never met philosophers before. I had read little philosophy, and so I found it very exciting. Above all, I was glad to discover that there were apparently no technical or glaring faults in my speciesism and painism arguments. I'm worrying about the time. I could run on too long. Jeremy Bentham never tied up the loose ends of his theory of intensity, but it needs to be done. Is Bentham saying that a pain of intensity X can cancel out a pleasure of intensity X? Few pleasures can overrule a pain, yet a pain can easily destroy a pleasure. Pains and pleasures themselves are things that are experienced. Hearing about several poignant pains happens frequently, but such experiences are not the same as actually experiencing such pains, nor of aggregating them. An unfelt pain is not a pain. It is just the report of a pain. A pain must be felt in order to be a pain. It seems obvious to me that pleasures and pains are the basic building blocks of all morality. In my childhood, I simplified all good and bad into just pleasure and pain. That took me a couple of years to accept, but I was fairly sure about it. For convenience, we can name an intense pain by the name of its maximum sufferer. There are differences between balancing, cancelling, and mixing pains and pleasures. Do pains and pleasures have to be contemporary or coterminous to be aggregated or balanced out? How long can a pain last? Minutes, months, or years? I wanted to get on with the politics of changing the law, but I found the young philosophers were reluctant to get involved in this. However, I was contacted by Peter Singer in 1971. He was a graduate philosopher from Australia, and unlike the book's editors, he liked my neologism, speciesism. We became allies and have kept in touch ever since. I get the feeling I must have covered 10 minutes. Thank you very much.
Greetings, everyone, and I just want to congratulate Raphael, Sean, Carolina, Eva for a fantastic conference. And I think, like Saskia mentioned yesterday, it's so wonderful to be amongst a group of like-minded people, because most of our contexts are not like that. So I want to say that I'm in awe about many of the proposals that are on the table, and also particularly the laws that have passed into fruition in Ohio and in Panama, as we heard yesterday. But many of us live in countries where direct animal rights legislation is unlikely. If such legislation were to be passed, it would also only operate in a very limited area and have a very limited impact. That is not to undermine the idea of rights for animals. As people will know, I agree with, and I've written about the justification for recognizing rights for animals. Yet many of our societies are not ready to recognize such rights or pass legislation enshrining them. And so if this is the case, how are those of us committed to animal rights, but also law reform, to improve the condition of animals to proceed? In the short presentation, and I'm sure we'll have more discussion as well, I want to make an argument that the very premises of underlying animal rights require us to engage with processes to reform animal welfare legislation. I wish to argue that some of the reforms to welfare legislation also have an important role to play in advancing animal rights. And I'm going to utilize a case study relating to recent animal law reform currently taking place in South Africa. I'm going to distinguish animal rights and animal rights-related ideas. And I'm going to suggest that placing ideas in welfare legislation can be a ground for future development or progressive realization, and that there are also important possibilities for judicial development. So animal rights is founded on the recognition of the intrinsic worth of animals and their treatment as an end in themselves in some form or another. What does this require? Well, some like Gary Franchione famously have argued that welfare reform simply entrenches subordination and it legitimizes exploitation. Our focus should be on ensuring people essentially go vegan and engaging in education towards that end. Now, there is some validity in this perspective, I'll admit, but I think it is ultimately mistaken. It requires relinquishing opportunities to improve the position of millions of animals gradually in the service of a utopian ideal. It essentially, in my view, makes the very mistake that it thinks it is trying to avoid. It treats animals as a means to some kind of ideological Puritan ideal. And to treat animals truly with respect, in my view, is to engage with all processes that allow improvements in their well-being. And particularly, that requires seeking to engage with these processes in such a way that creates opportunities for the greater recognition of their rights in future. So to the South African process, there's a new animal welfare bill that's currently being drafted. The current act dates from 1962, when South Africa became a republic. It was the height of apartheid in South Africa at the time. And there have been various amendments, but there has been no change to animal welfare legislation. What is the impetus for it? Well, the main impetus seems quite unpromising. In 2018, a socioeconomic impact study focused on the benefits of modernized animal welfare legislation. These include what it says: better animal productivity and health, better food safety and security, and an enhanced access or ability to international markets for animals and animal products. And that issue is quite important, and it raises the global context in which we work, because the EU for exports requires higher standards of animal welfare than necessarily exists in South Africa at the moment. And so that motivation has created an impetus in South Africa, right, surprisingly, to change its welfare legislation to meet those higher standards. Now, the motivation seems rather unpromising from a rights-based perspective and seems to encourage better welfare simply to ensure animals are exploited better, right? And it sees essentially animals in purely instrumental terms. But it's important also to recognize that the proposal takes place in other contexts too. The first context is that South Africa passed a democratic constitution in 1996, and that establishes the grounds of a future society which requires a shift in all law in conformity with the constitutional ethos. It is rooted in certain fundamental principles: dignity, equality, freedom, and when interpreting any law or legislation, every court must promote the spirit, purport, and objects of the Bill of Rights. In 2016, in a case which dealt with whether or not the National Society for the Prevention of Cruelty to Animals could prosecute a case, could bring what's called a private prosecution in relation to animal cruelty, the Constitutional Court made some very groundbreaking statements. And after surveying the history of animal protection legislation in South Africa, it said the following: the rationale behind protecting animal welfare has shifted from merely safeguarding the moral status of humans to placing intrinsic value on animals as individuals. So what does that mean? It means animals have value and are protected in their own right. It's kind of a recognition that animals have a type of dignity. And it means that where there is a clash between animals and humans, animal interests have to be considered. And so the new law is going to be drafted in this context. Other catalysts: science has evolved since 1962. Our understanding of animals and their sentience and consciousness has. That's a fundamental shift that's taken place. And another catalyst is also in context is the climate crisis, the recognition of our impact on the environment, and South Africa has a right to protect the environment, and the Constitutional Court in that same case recognized that animal welfare and conservation are intertwined. So when we heard that there was a process to reform the legislation that was going to take place, the institute I direct, which is an academic institute called SciFac, the organization I'm involved in as a director, Animal Law Reform South Africa, which tries to to push animal law reform, and Humane World for Animals, Ruud's colleagues in South Africa, decided to create a project called the Animal Law Project. And you can have a look online at what has resulted so far. To try and the objective was to create transformative animal protection legislation in South Africa as a constitutional imperative rooted in social justice and the changed understanding of animals in science and social science. The new law, the argument was, should be rooted in the Constitution and recognize the intrinsic value of animals, individuals. It should not reinforce colonial ideals, non-transparency, non-accountability, domination of the strong over the weak, environmental irresponsibility, and other harmful principles. So also thinking about the interconnections between the human, the animal, and the environment, something Saskia pointed out yesterday as well in various arguments. Now, we've created a manifesto. During my time as a judge, I had to step away from this project because it was inappropriate for me as a judge to be involved in legislative reform. So some of my colleagues took it forward, but they basically created a manifesto from the animal protection. There was a whole lot of consultation among the animal protection community. And essentially, I can't go through it. You can look at it online. But essentially, there are three foundational values which it is argued should be at the center of the new legislation. First, alignment with the new constitutional order, a recognition of sentience, and a recognition of intrinsic value. On that basis, there's a development of 10 guiding principles for the legislation. These include, I'm just going to give you a few examples, animal flourishing, protection for the vulnerability of animals, recognition of our connection to animals and our relationships with them, and rootedness in African philosophy, Ubuntu, which I'll come to a little bit maybe in the discussion, but it's something important to root ideas in ideas that are linked to the society within which we are. We heard some of this in relation to Ecuador and Panama. The duties of humans towards animals to avoid harm and to care for them, and where harm is unavoidable, a duty to justify in line with proportionality. Now, you'll notice that there aren't necessarily direct animal rights there, but there are many ideas that are connected with the notion that animals have rights. Sentience is a scientific notion, but it provides the foundation for the idea that animals count in their own right. The idea of intrinsic value in many ways underlies the notion that animals have worth and count as individuals. And the idea that animals have interests links with the notion of rights. The notion of a duty to justify interference with important interests links with the idea that animals have interests of a weight similar to those of rights. Now, it may not be possible now to entrench animal rights directly in legislation or constitutions, and in our assessment, it isn't at present. But it may be possible to include ideas connected with animal rights. And those ideas may well in time create a foundation for a recognition of animal rights, or at least a recognition of the implications of animals as rights bearers, which is essentially functionally equivalent in a certain way. And I want to give an example. I wrote a judgment. I was fortunate that a case came before us when I was at the Constitutional Court. Sean might be quite excited about this because it deals with an old Roman law principle. And for those of you who sort of going back to property law, it was a dispute in the leafy suburbs of Cape Town. Mrs. Burzak had a large property which she subdivided and sold in half. She nevertheless wanted to keep a bit of the adjoining property and a right to use it for her garden. And at the end of that part, she essentially placed a fence, and she registered what's called a servitude or a real right over that property, right? And she had the right to use that approximately third for gardening. Now, the problem was new owners came in and they had dogs on the other side of the fence, and the dogs could escape under the fence. There was a swimming pool on the other side, and her property also potentially could escape into the streets, etc., and be harmed. And they couldn't easily be retrieved. And so that began the dispute. The Baines went to Mrs. Burzak and said to her, can we modify the fence to keep our dogs in the property? And Mrs. Baines said, no way, the fence is staying as it is. It's been here for a long time, and that is the way. And it led to a major dispute. For those of you interested in the difference between predial and personal servitudes, you can look into it. But nevertheless, I looked at the case and I saw that there were dogs involved. This was a really important issue. And there's an old Roman law principle that when you exercise a servitude, you have to exercise it what's called civiliter modo, in a reasonable manner or in a civil manner. And reasonableness is traditionally understood to consider reference to the servient property of the servient owner's property interests. So you cannot burden an owner more than is necessary. And I basically utilized this principle, and I found that the interests of the owners included their duty to ensure that the animals they cared for were not harmed. So I recognized the interrelationship between the human and the animal interests. I also referenced back to the NSPCA case, which recognized the intrinsic value of animals as individuals. The interests of the dogs, I said, had to be weighed into the manner in which the servitude was exercised and its reasonableness. This recognizes in an ordinary property law case how animals are not things and must be considered in their own right. And it draws on constitutional principles to recognize that there's a constitutionally protected right of humans to form meaningful relationships with companion animals that can in turn provide protection for those animals themselves as well. And so it recognizes the need to think about how ordinary common law principles, and I know this won't apply to everyone who's not in common law countries, but for those of us who are, these principles admit of development as well to take account of the interests of animals and to achieve results that are positive for animals. It was, I should say, a minority judgment, so unfortunately it doesn't have concrete effect, but that lays I'm hoping that it lays the groundwork for thinking in the future, and it's now in the case law. So the example I want to demonstrate how an initial recognition of intrinsic value can allow and enable judges down the line to develop legal doctrines for animals. And so changes to constitutional legislation can create a foundation for progressive realization of animal rights in the future. We are not in a world where full realization of such rights is possible at present. Advocates for improved treatment need to consider, in my view, the modalities of the legal system that can create progressive possibilities for the future. In a sense, I talk about this as a sort of a legal platform for future development. Welfare legislation, I would suggest, offers an opportunity where there's reform going on to include advances in thinking in relation to animal sentience as well as moral theory. That in turn can create the foundations for progressive judicial development in the future. In conclusion, this presentation wants to recognize the potential complementarity of welfare and rights legislation. The express recognition of animal rights may be possible in a few cases, as we have heard, and there may be cases where abolition is possible as well. In most cases, however, that's not really true. That does not mean there are no opportunities for the improvement of our legislative frameworks. Improvements in welfare can be very important for individual animals, but it also may lay the foundation for the recognition of animal rights in future. Thank you very much.
Thank you for having me. My name is Ruud Tombrock, and I head up Humane World for Animals EU, formerly known as Humane Society International. So just to be clear, because I had many questions over the past couple of days, there were two organizations, Humane Society of the United States, HSUS, and Humane Society International, HSI, who changed their name, both of them, in February this year, actually. And we sort of joined forces and went together under a new name, Humane World for Animals, just to be clear. So Humane World for Animals is one of the, as Eva introduced me, one of the largest animal protection, animal welfare organizations in the world. which strives to improve the lives of all animals. You may know us of the work that we do on dog meat trade, which resulted in a legislative ban in South Korea on dog meat farming, which come into effect in 2027. In Europe, we're known for our work in Ukraine, where we have a big partnership with the Ukrainian Red Cross. And also the fur farming bans in Romania in 2024 that was agreed, and in Italy in 2022. And some of you may also know us from the Save Ralph animation video on animal testing, which helped to create more awareness for the testing, which uses animals in particular in Latin America countries. It got traction, and it helped to get a ban, for example, on cosmetic animal testing in Mexico. That's what we do. We work on ending animal cruelty and suffering worldwide, and focus on the root causes of the cruelty, and hope that the changes that we manage to create are going to be permanent by doing it that way. I would describe our approach as a pragmatic approach, driven by ideals and a strong and heartfelt passion to create a better world for animals. In the EU, most of our work is focused on improving legal protections for animals across the EU. And as many of you know, the vast majority of animal welfare laws and regulations in the European Union are being set at the EU level. They're not at the individual member state level. For example, laws on farmed animals are agreed on by the EU institutions, and once they agree, they will all apply to all 27 member states in the European Union. That all has to do with the fact that the European Union wants to create that level playing field. That's why the EU institutions have that role. Individual member states can choose to go above and beyond the EU standards, but if they would create a situation then in their country which would decrease their competitive edge compared to others, then the EU institution may say, well, yeah, that's your problem. Until the moment has come that several member states do that, then the EU institution may say, okay, well, maybe all of us should be doing that to create a new level playing field again. That's basically how it works. Now, let me see if I can do this. Yep. The animals we speak for have no vote, no seat in the European Parliament, no voice in the Council of the European Union. Their welfare depends entirely on our ability to convince decision makers to act, to respond to both public morale concerns and science, and create new or improve existing legislation. At its core, our work is about ensuring that compassion is not just a personal sentiment, but a legal obligation. Let me say something about a few key battles that we have been working on. And let me start with farmed animals. In 2021, the European Commission committed to introducing legislation to ban cage confinement for farmed animals. By the end of 2023, they were going to propose new legislation to phase out of all cages and crates for a long list with animal species. A promise that was widely celebrated as a breakthrough for the animals. This was a response to the European Citizens Initiative to end the cage age, which was signed by nearly 1.4 million citizens. Yet, by October 2023, it became evident that the Commission would not deliver on that commitment. This backtracking was deeply disappointing, not only because it has prolonged the suffering of hundreds of millions of animals each year, but also because it undermines public trust and faith in the EU institutions. On fur, we've seen a wave of national bans on fur farming in the EU member states, which reflects the overwhelming public opposition to and strong ethical arguments against the exploitation of animals for their skin, for fur. Yet we still lack an EU-wide prohibition, and there's pressure from industry to hold the line despite a recent scientific opinion by the European Food Safety Authority, EFSA, which clearly states that the conditions on fur farms across the European Union fail to meet the basic animal welfare needs for mink, foxes, raccoon dogs, and chinchillas. In other areas, such as the use of animals for chemicals testing, politicians often express positive intentions, but reality paints a different picture. In disaster laws, animals, including those we keep on farms and as our companions, simply seem to be completely forgotten. I can share with you that a few months ago I was in Geneva at a UNDRR conference, UN Disaster Risk Reduction conference, 3 days, God knows how many sessions and presentations about early warning systems and how we should make humans more prepared for the increasing number of natural disasters that we're expecting. And the word animals was not used one single time, 3 days of presentations. So it's not on the radar there. Now, how we work. We operate at 2 levels, the EU institutions and the member states. EU institutions, we engage with European Commission, Parliament and Council to push for ambitious legislative proposals and defend the existing protections. The European Commission has the right of initiative to propose legislation. It manages the EU budget and it ensures the implementation of EU law. It conducts impact assessments and public consultations before drafting the laws. The European Parliament is composed of 720 MEPs, members of the European Parliament, amongst other things, it reviews the legislative proposals that the EU Commission comes up with. It introduces amendments and votes on legislation. The Council of the European Union represents the member states via the national ministers who meet in different configurations. For example, the Council on Environment, Agriculture. Second level, on the member states, once the Commission tables a proposal, the member states, through the Council of the EU, are co-legislators with the European Parliament. So member states can influence the legislative process by building coalitions and by lobbying the Commission. Given that we as an organization cannot campaign, we simply do not have the resources to do that in all 27 member states. We would love to do that, but it's simply impossible. So what we do is for each campaign, for each piece of legislation, we identify the member states that we think are going to be the most strategic and influential, the ones who may block improvements, the ones who may endorse it, support it. Those are the ones that have something at stake, basically. By building coalitions with the local NGOs, mobilizing public opinion and trying to use national governments as our allies, we strive to drive change in Brussels. And we, Humane World for Animals EU, are now running campaigns in 8 EU member states. To be effective, our approach needs to integrate knowledge about the legislative and political process, scientific evidence, political networking and lobby skills, and public campaigning, because lawmakers respond usually, often, to a combination of facts, values, and public pressure. Was that a peep to hurry me up, or yeah? Oh, okay. So over the past few years, and I would like to say something about that because I think it's very relevant. Over the past few years, the political climate in Europe has significantly shifted. Economic concerns, security issues, and political polarization have contributed to animal welfare being pushed down the political agenda. We face stronger and better organized industry lobbying, at times aggressive lobbying, greater caution within the Commission, and also in some member states, active rollbacks. And yet, public support for strengthening animal welfare legislation continues to remain incredibly high. This is probably our strongest asset. So if we don't act decisively now, we risk losing the hard-won gains over the past decades. We are seeing that under the guise of modernizing or simplifying legislation. Some of the rules protecting animals from commercial exploitation have come under pressure. But we also have opportunities, legal precedents, cross-party allies, and the momentum of public opinion. And this is why I think that collaboration between NGOs, academia, and policymakers is essential. We each bring different tools to the table: legal analysis, political access, research, and public mobilization. So, to conclude, lobbying for the voiceless is slow, painstaking, and often very frustrating work. But it is also, I think, deeply rewarding. When we secure a new protection in law, it can permanently change the lives of millions of sentient beings. My hope for today is that we can share some strategies and that cut across our disciplines, so that despite the current political challenges, the arc of European law continues to bend towards achieving greater justice and better lives for animals.